the Magna Carta existed to promote freedom from tyranny, and some feel that the litigation system has evolved into a particularly egregious form of tyranny. Nowhere are the stakes higher than in class actions. And that's the subject for our panelists this morning, with additional remarks that they'll make about litigation financing, how class actions are financed. Each of our guests here is going to talk about a jurisdiction that's a progeny of English common law. And recognizing that you may not be as familiar with these systems as you are with the United States, we've asked each person to start with some brief comments about a feature of their jurisdiction or features of their jurisdiction that relate to class actions. So we're going to start with Ken Daly. Ken from Sidley, Austin. He's based in Brussels, but he's Irish, and I tell you that so that you won't sit there wondering what his accent is. He's been working with us at ILR on legal reform in England and Wales, and he also is able to provide some EU context for class action discussions. So Ken, I turn it over to you.
Thank you, Mary. Thank you for the introduction. I hope my accent isn't too impenetrable. So a few words from me in particular about the situation in the UK, the home, of course, of the Magna Carta. Europe in the last few years has seen enormous changes. We've just had a short introduction in relation to France, where of course there have been huge developments, but I wanted to focus in on the UK in particular, because the UK has been going through a very radical cultural shift in relation to its legal environment. Now there have been collective actions, types of class actions available in the UK for some time, for some decades. But what's interesting is that they have really only started to be used in very recent years. We've seen very significant collective actions now filed in relation to securities law, in relation to product liability. The recent revelations about Volkswagen emissions, for example, have led to great excitement in the UK about what sort of actions in particular might be filed. There have been employment law collective actions, environmental, medical negligence, you name it. So what I think is of interest for our discussion is what has changed. Why is it that the UK is now suddenly embracing these mechanisms that have been around for a while? I think the answer to that, unfortunately, it can be revealed by following the old cliche about following the money. The government has taken a view that more litigation is necessary and that more access to justice would be a good thing. And part of the way the government in the UK has achieved that is to lower the barriers that previously existed to novel types of funding arrangements. Some years ago already there was the introduction of no-win, no-fee arrangements, which had their own certain effect. And from the beginning of 2013, the government introduced a US-style contingency fee arrangement for the first time. And now, the contingency fee hasn't really been taken up. The reason the contingency fee hasn't been taken up is mainly that third-party litigation funders jumped in there and got there first. Third-party litigation funding, by which I mean investment by uninterested parties, private equity, for example, investing in a lawsuit in exchange for a promise of a percentage of the outcome. Third-party litigation funders have really begun to saturate the UK market in particular, and the assets available to them and the level of activity has really multiplied enormously. There's just one slide I'd like to show you on that, if I may, which is the capital, the assets under management by the litigation funders in the UK. As you can see, between 2009 and the end of 2014, there's been a 743% growth in the assets available to invest in litigation in the UK. So that steep curve is really a very prominent feature of what's happening in the UK right now. So it's almost as if the law firms, although it's possible to invest in cases on a contingency fee basis, they're choosing not to. They're preferring instead to offlay the risk to the litigation funders. Now I'll finish by saying that there's one other thing. You would think that all of this is a radical enough change for any country. But in fact, the UK government has taken one step further. Since the 1st of October this year, the new Consumer Rights Act has been introduced in the UK, which introduces Europe's first ever US-style opt-out class action. All of the actions that I mentioned up to now are really opt-in actions, which are ordered by the court, individual actions which are glued together in these things called group litigation orders. But now the UK has permitted full opt-out actions. The president of I should say that they are limited for now to competition, to antitrust cases, but there's a very strong expectation that this is an experiment, and in the event that it's deemed successful, it will be rolled out to other areas of law. So the move towards a US system in the UK is simply undeniable. The president of the court that will deal with these class actions has said in a speech in the last couple of weeks that there isn't the body of experience available in the UK about how to run these actions, and so they're going to look to the US, to Canada, and to Australia as the benchmark and the model for how these things are going to roll out. So the internationalization of class actions is undeniable.
A scary prospect. Okay, let's follow that with Gordon McKee from Blake's law firm, who will tell us a bit about Canada.
I'll start by thanking Mary and the ILR for inviting me to talk on this panel. It's a particularly timely topic for lawyers from Ontario like myself, because one of the surviving copies of the Magna Carta is on display in Toronto right now. And we also have our Law Commission looking at the last 20 years' experience with class actions in Ontario and potentials for reform, which is a very important development. Most Canadian jurisdictions, provinces have legislation allowing class actions in Canada. We don't have an MDL-like process that provides for coordinating competing class actions among the provinces, which makes things complicated. The thresholds for certification in Canada tend to be lower, or generally felt to be lower than in the US, and cases that wouldn't be certified here are getting certified in Canada. The evidentiary burden on plaintiffs in terms of the class action criteria is lower. The Walmart and Duke standard, which many of you are familiar with, was rejected by our Supreme Court of Canada in 2013. While we don't have a merits assessment in the certification criteria, a number of the provinces have loser pays costs for class actions, which essentially is there to try and discourage meritless claims designed to extort settlements because of the extraneous pressures that many of you are familiar with in these circumstances. I have one slide to show in terms of trends on the volume of cases. It's very difficult to get data from data in terms of the class actions in Canada because there isn't a central electronic registry, but if we could pull up my first slide, it has some data in terms of, from a Canadian class action database, which essentially shows that to the extent it's reliable, the possible trend in increasing class actions in Canada and in Ontario, which is one of the most active jurisdictions, relatively flat in the two other active jurisdictions, Quebec and BC. In terms of funding, which Ken talked about, both private and public funding, third-party funding, is available depending on the province. In Ontario and Quebec, we have public funding available. In Ontario, just for disbursements, the lawyers' disbursements. In Quebec, it includes fees as well. In terms of private funding, third-party funding, that's a relatively new phenomena. We have had a number of courts approve it. This is a slide of the public versus private funding in the common law provinces. So other than Quebec, you'll see there have been 7 approvals of private funding since 2009. Only 1 rejection, by the way. It's not that they're rejecting a lot. In Quebec, it's difficult to get good data on the private funding, but this shows you the volume of public funding available in the past. The Ontario lower courts have considered whether third-party funding, private third-party funding is champerty, should be against public policy, and have approved the funding on certain conditions. Basically that there be, at the outset, disclosure and approval of the funding arrangement, that the funder not have any control over the litigation, and that the fee be reasonable. So our fees have actually been in the 7 to 10% range in terms of the awards. The last thing I guess I'll say in terms of funding is that there is some concern on the part of many defendants, notwithstanding the controls that the Ontario court talked about, that if funders are making decisions on funding based on their portfolio and spreading the risk, and the frequency with which cases are settled, it will dilute the effects of the loser pays costs rule in terms of discouraging meritless litigation.
Thanks, Gord. Now to round out our preliminary remarks, we'll turn to Moira Saville, who's from King & Wood Mallesons in Sydney, Australia. In Australia, by the way, one of the few original copies of the Magna Carta is permanently housed, as I understand it. So Moira?
Thank you, Mary. In Australia, we have a unique class action regime. It's a little bit different to the other ones that we've talked about in our federal jurisdiction and in some states. We have very low thresholds to start a class action. 7 class members, as little as one common issue of fact or law, and that's it. We don't have an early certification process at all, so it's very hard to stop class actions or strike them out at an early stage. We have an opt-out procedure, but in reality, a lot of the class actions are actually opt-in. And we don't have contingency fees in Australia, at least not yet. And so that has really left the way clear for the litigation funders. In fact, I think the Australian litigation funders take credit for the fact that it's an Australian product that they have in fact exported overseas. So we've had class actions in Australia for about 20 years, but we've really seen an exponential growth in the last sort of 9 years. And I've got, if you could bring up the first slide, you can see at about 2006, 2007, we've had a real upswing in class actions. This is a slide that shows the settlements, the aggregate settlements in securities class actions in Australia, which have now exceeded the $1 billion mark. And at 2007, you can see this uptick, dramatic increase, and that's due to 2 factors. One, we had a GFC like everywhere else in the world, and so there were a lot of securities claims and financial mis-selling claims. But secondly, our highest court held that litigation funding was a legitimate business, and it was not an abusive process in those states of Australia where we had abolished champity and maintenance. And this is an interesting decision because this was notwithstanding that the court found that the funders had control of the litigation. So very different to the Canadian situation. It was found that the funders could seek out the class members and that was okay, and that they were described by the court as a speculative investor in the litigation. But nevertheless, it was held to be legitimate, and we've seen the results since then. Now in Australia, we have, I think, 17 funders operating here. No, it'll be that slide. I'm not sure I know how to go back. So we've got a number of funders here operating in the Australian market. A number of them are homegrown. We've got some overseas funders as well. They're hedge funds, venture capital, and we've even got one funder, the largest, who is listed on our stock exchange. Since that time, we've seen a diversification in the kinds of actions and an increase in the kinds of class actions. And if I can go back, we're seeing claims, human rights claims, government claims against government, environmental claims, consumer claims, as well as securities class actions. And I think probably what we're seeing is class actions have now in Australia entered the popular consciousness. I mean, I think that is actually something I suppose that you may be used to in the US and in Canada for some time. For us in Australia, I think that is actually quite a new thing. So class actions now are regarded as an immediate response to any event or problem, from things ranging from franchisee disputes to food poisoning in a restaurant. The first thing that the press talks about is the class action, and then we see the funders and the plaintiff lawyers go from there. The next thing I think that will happen in Australia is contingency fees. There is a move for that at the moment, a very strong push in Australia, and I suppose in that sense we are becoming more like the US. I think we think that it will bring more class actions in Australia. I think that there's sort of no doubt about that it will increase class actions as well as increase competition with the litigation funders.
Class actions that are already very much on the rise.
That's
Okay,
right.
so that kind of gives us a bit of a grounding in these three systems, and now I'd like to back up and get a little bit more philosophical about this, reflecting on the video that we saw at the introduction. What does the rule of law mean in your country in the context of class actions? Do you see an evolution toward a greater focus on it? Do you see an evolution away from it? What's your thought about rule of law as it plays out in these systems? Let me start with you, Ken, since you're conveniently to my right.
Well, I guess we have to ask what we mean by rule of law. If the question is society reaching to law for the solution to its problems more often than in the past, then I think, based on what Moira just mentioned, certainly in Australia that seems to be the case. It also certainly seems to be the case in the UK. Rule of law can also be seen, or if you think back to the origins of rule of law, it really was to balance different elements of society, to balance the power of government, the power of different actors within society, the power of, say, corporations, the power of individuals, and to provide a mechanism whereby their rights and interests can be balanced. It seems to me that there have been hundreds of years in European jurisdictions of successful balancing without the need for any type of a class action. But the discourse at the moment assumes that there is now suddenly an imbalance that needs to be redressed, and that it's consumers that are on the receiving end of that imbalance, and that the system needs to be remade in order to protect their rights. And why that is, I'm not entirely sure.
Thoughts from the two of you?
I was intrigued by this question when you first raised it with us, Mary, and looked at some of our Supreme Court decisions, in particular one in 2005 where the Supreme Court of Canada basically held that if a law is properly enacted in accordance with the requirements for enacting legislation and consistent with the Constitution and the Charter, you can't use the rule of law to say that the law is unfair. And so the focus I see going forward is really on reform. The case that issue came up was one where the court had to consider whether a BC legislation allowing claims for recovery of tobacco-related healthcare costs specifically targeted at tobacco companies and changing the burdens of proof in favor of the BC government was valid legislation, and they considered specifically whether the rule of law would allow it to be struck down because it was unfair, and they said it didn't. So I think we have to focus, to the extent that people believe the legislation, the class action legislation is unfair, providing unjust outcomes because it's based on not on merit anymore, to focus on initiatives like the Law Commission of Ontario that's looking at changes in the class action legislation.
I thought it was a very interesting question. I mean, in Australia, I think, like other countries, we all think that we respect and observe the rule of law. But picking up on Ken's point, when you think about the sort of exponential growth in class actions we've had in Australia, I think we had double the number of class actions filed in the past year as we had for the previous 2 years. You sort of have to think about, I suppose, whether more litigation really equates to the rule of law. So in that context, I guess I'll make two comments about Australia. First of all, almost all of the class actions in Australia settle. And it's interesting, actually, because the ones that go all the way to trial almost always fail. But what we're seeing is people using the courts but not going to court, if I can put it that way. They're using the court system for an outcome, a financial outcome, but we're not seeing judgments. And a consequence of that in Australia is that in Australia, class actions don't make new law, except about class action procedure. That's it. They don't actually change the world. They don't actually change the law. With one or two very rare exceptions, they just make law about class actions.
So one of the traditional arguments pro-class action arguments, which I will try very hard to make, although it's going to be difficult for me, is that they enhance access to justice. So Ken talked about access to justice a little bit. Access to justice has been a big deal throughout jurisprudence, and that particularly an opt-out system, which doesn't require people to take many affirmative steps to benefit from litigation, is an access to justice enhancement. So you've all talked or at least alluded to this sort of opt-in, opt-out difference. And I'm interested to hear what you might want policymakers in your country to know about opt-out and opt-in systems as you look at their benefits and the access to justice issue and their detriments, which is kind of where we've been at ILR. Anybody, hop in.
Well, I'll start if you want.
Sure.
We have an opt-out system in all the provinces, except with respect to a few where there's an opt-in for non-residents, but it's still opt-out in the local province for local residents. And one of the things that the Law Commission identified as troubling was low take-up rates. Well, if you have an opt-out system, and particularly if you have an opt-out system like ours, where we often have broad class definitions that aren't tied to the injury at issue, it's not surprising and shouldn't be surprising to anybody that we have low take-up rates. Many would think that they're low because of just because there aren't very many people with the injury at issue. But that shouldn't come as a surprise. And the second thing is that the belief of many is that if you have an opt-in system, it will do a better job of measuring whether there really is a need for the class action from a social and policy perspective.
Yeah, I'd certainly agree with that. I mean, I guess the one question that indeed has already been asked to the regulator in the UK about opt-in, opt-out, the question was, do you really need it? Do you really need opt-out? And as I mentioned, the answer very much was yes. There is a mechanism built into the UK's new opt-out system, which already foresees that there will be low take-up rates. They've created a CPRA mechanism specifically with a view to distributing the damages to an Access to Justice foundation. So there's a kind of a circular argument there that you need opt-out in order to generate access to justice, but then when people don't take the justice that they're given access to, you don't put the money into the Access to Justice foundation in order to generate further access to justice. So it's,
The circularity there that's kind of disturbing. Access to justice. Oh, go ahead, Moira. Did you have a comment?
It's interesting that access to justice is the argument for class actions, but the litigation funders in Australia do not argue access to justice at all. They've sort of moved on for that and recognised that it's a profitable business for them, and that's what it's really about. So that's not an argument that is really played out in Australia anymore. We do have an opt-out system, but as I said in my opening remarks, it tends to be opt-in to a large degree, and that's because of the litigation funders, so they sign people up to a contract. We don't have any problem with take-up rates in Australia at the moment, but the interesting phenomenon we're seeing in Australia is that the funders have decided that they don't just want to get their 20 to 40% commission from the people who sign up to them. They'd like to have opt-out class actions so they can get a bigger class of people and therefore a higher return, and they'd like to get their percentage from everybody, whether or not they're signed up to a contract. And so some of the funders have approached our courts and made applications recently and asked for court orders, a bit like the common fund approach that I think you have in the US, asked the court to approve them taking their commission from everybody. To date, the courts have not done that, but that would be the thing that I would raise with our regulators, because for us, I think that overrides the fundamental law of contract. These people will not have signed up to a funder, but they'll have their money, they'll have their ticket clipped by the funder if they participate in the class action.
So let's turn the conversation to funding for just a moment. We heard Colleen Graffey in the introductory video talk about the concern that courtrooms were becoming casinos, and of course a big part of Magna Carta. I keep pulling us back to Magna Carta because it's so foundational. was a prohibition against selling justice. So is justice being sold now? I know we have, probably you are not all fans of litigation funding here, but can we be a little thoughtful about thinking about that casino metaphor and the sale of justice? Any thoughts about that?
I think it's right to, I mean, law is and has always been a business, but I don't, to my mind, that's not the same thing as selling justice. I think there's a very long tradition in all of the jurisdictions, including, of course, the US, of this is a word for the profession, in case it looks like we're unnecessarily lawyer bashing. I mean, there's a long history of providing counsel, advice, services. But it seems to me to be a fundamentally different thing when the lawyer, or indeed the third-party funder, has their own stake in the outcome. That to me moves it quite far away from the original concept of a counsellor to help somebody in a difficulty through the to navigate the legal environment. It makes the lawyer or the third-party funder a party with their own interest in the outcome, and how to resolve those conflicts is still very much being worked out in the UK.
Well, particularly where, as in Australia, the funders are initiating litigation and are permitted to solicit claimants. Do you see that happening as the funding process evolves? Is that a threat that's a concern? Is that something, for example, that could happen in Canada?
I mean, I would be very surprised. I was quite surprised to hear that in Australia the funders can actually initiate, advertise, and control to some degree the litigation. I think certainly our courts, to the extent they've looked at private funding so far, have put constraints that wouldn't allow any of those things to happen, and I would be surprised if they would ever adopt such a thing. But we don't have formal statutes or regulations in place yet that tie people's hands. It's basically ad hoc by judges, and until we do have perhaps the controls that the lower courts have talked about implemented into statute, which hopefully the Law Commission will do as a minimum, I guess we're at risk of that. I just don't see it happening.
I mean, we have quite light touch regulation of funding in Australia. The interesting thing is that what we do have is that the funders have to manage conflicts of interest between the interests of the class and their own commercial interests. I always laugh at that because as lawyers, we're a profession, and we can't manage conflicts. We're just not allowed to have them. But for funders, it's okay as long as you can manage it. We have seen some interesting examples of that. Sometimes in settlements, the funder actually wants to settle because they have got an amount that gives them a decent return over the life of the class action, but in fact the plaintiff law firm wants to go further and they want to push on, and there's an interesting tension that we've seen develop in some settlements in that regard.
That reminds me of an interesting point about one of the features of the new UK class action mechanism. There's a rule in relation to funding which says that lawyers cannot act in these opt-out class actions on a contingency fee basis, specifically because that would tend to introduce negative incentives into the system. But simultaneously, they have permitted third-party funders to fund the exact same class actions. So you have a situation where lawyers who at least are subject to an ethical code, fiduciary obligations, etc., are barred from taking the risk, but third-party funders are free to. And there is no regulatory system. There's no government-imposed regulatory system for third-party funders in the UK. Instead, a voluntary system has been set up, which many of the funders have subscribed to, but many have not. And the consequence for breaching
only seven of them,
yes. Yeah. And there's a self-regulatory code, which, because it was written by the funders, is obviously very favourable to their positions. But in any event, the consequences of breaching that code is exclusion from the voluntary organisation. So that's it. So
isn't there something in there about belonging to a club that wouldn't have you as a member or something? but if that happens, if they're kicked out of the organization, they can still fund litigation.
Absolutely, right? And there have in fact been some examples of of funders leaving the organization and continuing business as usual.
So is there any, oh, I'm sorry, go ahead.
I was just going to say, Ken points out the interesting interplay between contingency fees and the third-party funding.
That's where I was going.
Oh, excellent.
Go ahead.
We actually had the legislature, when they allowed class actions in 1993, say that you could have contingency fees, that plaintiffs could recover contingency fees, which up to that point, we weren't allowed in Canada. It was about 2002, I think, before the courts allowed contingency fees across the board. So they were trying to encourage access to justice with contingency fees, but hadn't contemplated the third-party funding at that point.
I think our Productivity Commission came out in favour of contingency fees on that access to justice basis. And I think also our Law Council has endorsed it. And one of the arguments has been that the law firms can then bring a class action at a lower percentage than the funders. The funders are 20 to 40%, the lawyers could charge 17 to 20, and could bring class actions that are not economically viable for the funders. So the funders don't get out of bed for less than 50 million. The law firms could bring a class action that's worth, sort of that sort of $10 to $20 million range. So,
Yeah, you could end up with class actions where you have theoretically both a contingency fee for the law firm, this is happening in the U.S., and a contingency fee for the funder, and that leaves almost nothing. I mean, so much for access to justice for the claimants, right?
That's true.
Many of our lawyers the plaintiffs' lawyers would stay away from the funding because the contingency fee that the court will approve to some degree is based on the amount of risk they took. If they took on the risk of the loser pays cost system, then they could argue for a higher percentage contingency fee. So we actually, in Ontario, I think only about 10% of class actions have been funded either publicly or privately to date.
So what's happened to champerty and maintenance and barratry? Are those just out the window for third-party litigation financing? Are those still arguments that can be made in any viable sense?
In the UK, I think it was in 1966 that the offences of champerty, maintenance and barratry were decriminalised. They used to be criminal offences. And there's been a series of cases since then about what exactly is permitted and what is not. So I think the short answer is yes. In the UK, they seem to have moved quite far away from prohibitions on that. There is still a small, maybe, chink of light in that a public policy argument can still be made that something is champertous. So it exists, but I'm not aware of any case in which somebody has successfully argued champerty to disrupt a funding mechanism. And in any event, one's unlikely to make that argument because funders' arrangements are typically not disclosed. There's no obligation to tell the court or indeed the opposing party about them. So they're often in the background.
Hidden champerty.
We're still talking about it in terms of the approval of the private funding. It is certainly a topic that's front and center, and that's why I think we've had conditions that say you can't incite it, is largely driven by the idea of champerty and stirring up litigation for an improper motive for a profit is still very much a topic of discussion, even though as in the UK, it's not a criminal offense anymore.
It's gone pretty much in Australia. I mean, it was abolished, decriminalised in the early 90s in some states, and in the states where it is still sitting there on the statute book, they don't have a class action regime. So you don't see class actions in those states.
But it's a guaranteed outcome now, almost, that when there is, for example, some sort of a decision of a competition authority or a decision of some sort of governmental authority that a business has been involved in some form of wrongdoing, that, just like in the US, within a very short period of time, there will be third-party funders traveling around Europe pitching, road showing cases. Here's how it's going to work. Here are our fees. Here are our terms. It is exactly the sort of thing that you say is not permitted in Canada is happening every day in Europe now.
Well, we hope it's not permitted in Canada. At least a couple of judges have said it's not so far.
Gord, you mentioned in your preliminary remarks that in Canada, funders are imperiling the deterrent effect of loser pays on filing non-meritorious litigation because they indemnify claimants against costs in the event of a loss. Is that happening elsewhere? And if those indemnities are occurring, why isn't it the case that that's going to make funders more careful about the lawsuits they choose to fund. This is one of their big arguments, of course. We do all kinds of due diligence. We don't fund lawsuits without merit. And their indemnity of costs would seem on the surface to support that claim.
For me, funders are not stupid. I mean, they indeed do care for due diligence of the cases that they're going to invest in. But like any investor, like anyone speculating on the stock exchange, for example, one takes a portfolio of cases, low risk and high risk, and you go with the flyer, and you go with the sure thing, and you balance them all out. And that's very much the way that funders seem to be approaching the litigation market, as taking a higher risk and lower risk. So I believe there are many cases in which they will consciously take more speculative cases that otherwise perhaps wouldn't make it to court at all.
Whether or not they're on the hook.
Right.
Could we turn the mics on a permanent basis? I feel like we're missing the first few words of what everyone's saying. Thank you.
It's difficult to believe that a funder wouldn't look at the percentage of cases that settle in assessing whether or not they want to take on the risk. Now, the one thing we've got going for us, we have had about 20 trials in Ontario, and the defendants have, when you take into account appeals, won about half of those. And because we have loser pays, and with the size of the loser pays and the fact that the funders typically take on the loser pays exposure, they might be taking a harder look at it in Ontario, but a number of our provinces don't have loser pays as well. So,
I don't think it is a deterrent at all in Australia when you look at the economics of it. I mean, particularly if you look at the securities class action space, all but one class action has settled before trial. The one that went to trial, they failed. In fact, the funder lost, although it's now on appeal. But if you look at the economics, the cost of a class action is about, say, 10 million. The return at the other end, if they get a settlement, is in the realm of 40 million. So the economics, I think, just mean that loser pays is just not a deterrent.
Unfortunately. If you could affect one change in class actions in your country to improve fairness, what would it be?
I've got a shopping list. But, so licensing of funders, I think, is something that there's been a debate about in Australia, and ILR has been an active participant in that debate for a long time. I think that would be a very good thing. I'm going to sneak in a second one and say no common fund, because I think that would change the landscape for class action. So this is this idea that I mentioned before, that funders should be able to get their commission from everybody in the class, whether or not they have chosen to sign up a contract with the funder. So we have some class actions where you've got people who have chosen to fund and people who come along for the ride in an open class. And I don't think the rules about the contract should be overridden in Australian class actions.
Is there a prospect of those changes happening?
Well, the court knocked it back when the application was made recently, but they found that they had the power to do it. It just wasn't appropriate in this case. So the door is potentially still open there.
So far, so good, but we've got to see what happens. Okay, Gord, do you have thoughts about this for Canada?
I have a shopping list too, but I'll focus on the certification threshold. I mean, I would like to see the normal burden of proof, the Walmart and Dukes evidentiary standard be incorporated. And I know the Law Commission is looking at whether we should have a merits assessment of some kind in the certification test. It was originally recommended when the legislation was thought about in 1982 by the Law Commission's predecessor. And it has been successful to some degree in the securities class actions, because there's a merits assessment on a leave test. For the secondary market litigation, they have to get leave to start the class action independent of the certification threshold, and there's been some success there. So those would be the things I would focus on.
I would probably say that because, in particular, opt-out class actions in the UK, and there are no other opt-out class actions really anywhere else in Europe, or not any very significant ones. I think the message that the president of the court that will be dealing with these gave, that I mentioned earlier, that they hope to learn the lessons from the US, from Canada and Australia. Well, I hope they do that. I mean, it sounds like a smart thing to say, but it seems that insufficient regard is being paid to the downsides, to the negative consequences. So my one wish would be that they think of a whole list of safeguards and gradually release them if indeed there's a case for that. But it seems to me that starting with a wide open US system in the hope that somehow Europeans are going to be smarter and not allow this to get out of hand seems a bit fanciful. So I would start with high safeguards and see what happens over time, but rather than doing it the other way around.
Is there any way to extricate class actions and funding, realistically?
Not in the UK.
Not in the UK,
No,
and not in
I
Australia.
don't think so.
I think
Yeah.
we're past that discussion.
We're past it, yeah. What's your advice to clients that are facing a funded class action? Do you have any particular one stellar piece of advice?
Prevention is better than cure, I'm afraid.
We're moving a lot to summary judgment now to try and deal with meritless cases. We've seen more of that both pre-certification, at certification, and post-certification. It's something people are looking a lot harder at because we have a perhaps more generous summary judgment test in Ontario, for example.
So that is a tool that you could use in Canada, but perhaps may not be as available elsewhere,
No.
right?
Very, very hard to get summary judgment in Australia, generally
Great.
speaking.
Well, I want to thank all of you very much for your thoughts about this, and to remind the audience that if you have questions for any or all of our panelists, send them via email to legalreform@uschamber.com, and during the Q&A session, they'll be very glad to answer your questions. Thank you very much.